Hello again, Canada. Alex Monahan here, Foundations Party, ineligible. I just wanted to apologize to everybody about yesterday. I only actually managed to post one video. Today's date is April 21st, 2017. And I just wanted to pick off where we left off yesterday, at the bottom of paragraph 111. Referrals. Subparagraph 2. The Refugee Appeal Division may make a referral described in paragraph 1C only if it is of the opinion that A, the decision of the Refugee Protection Division is wrong in law, in fact, or in a mix of law and fact, and it cannot make a decision upon paragraph 11.1a or b without hearing evidence that was presented to the Refugee Protection Division. Regulations. Paragraph 111.1, subparagraph 1. The regulations may provide for any matters relating to the application of this division and may include provisions respecting A, timelines of the provisions of documents and information under subsection 99, 3.1, or 104. B, time limits for the hearing referred to in section 100, subsection 100 brackets 4.1. C, exceptions to the application of paragraph 11.2d, D, time limits for the findings of finding and perfecting of an appeal under sections 110, 2.1, and E, time limits of the making of a division of Refugee Appeal Division, the extension of those time limits, and the circumstances in which those do not apply. Clarifications regulations made under paragraph 1b with respect to claimants who are nationals of countries, that is, on the day of which their claim is made, a country designates under subsection 109.1, subparagraph 1, regulations made under paragraph 1b may provide for time limits that are different from the time limits for other claims. Division 3. Pre-removal risk assessment. Protection. Applications for protection. Paragraph 112. So paragraph 1. A person in Canada other than a person referred to in subsection 115.1 may, in accordance with the regulations, apply to the Minister of Protection if they are subject to a removal order that is in force or are named in a certificate described in section 77.1. Exceptions. Subparagraph 2. Despite subsection 1, a person may not apply for protection if A, they are the subject of an authority to proceed issues under section 15 of the Extradition Act. B, they have made a claim to refer protection that has been determined under paragraph 101, subparagraph 1e, to be ineligible. B1, the subject to subsection 2.1, less than 12 months, or in the case of a person who is a national of a country that is designated under subsection 19.1 less than 36 months have passed since their claim for refugee protection was last rejected, unless it was deemed to be rejected under subsection 109.3, or was rejected on the basis of section E or F of Article 1 of the Refugee Convention, or determined to be withdrawn or abandoned by the Refugee Protection Division or the Refugee Appeal Division. C. Adject to sections 2.1 less than 12 months, or in the case of a person who is a national of a country that is designated under section 109.1, subparagraph 1. Less than 36 months has passed since their last application for protection was rejected or determined to be withdrawn or abandoned by the Refugee Protection Division or the minister, and subparagraph D has been repealed. Exemptions. Paragraph 2.1. The minister may expect for the applicant of paragraph 2, B1 or C, a national, or in the case of persons who do not have a country of nationality, the former habitual residence of a country. B. The nationals or foreign habitual residents for a country who, before they left the country, lived in a given part of that country. And C. A class of nationals or former habitual residents of a country. Application, subparagraph 2.2. However, on exemption made under subparagraph 2.1 does not apply to persons in respects to whom, after the day on which the exemption came into force, a decision is made respecting their claim for refugee protection by the Refugee Protection Division, or if an appeal is made by the Refugee Appeal Division. Regulations 2.3. The regulations may govern any matters relating to the application of subsection 2.1 or 2.2, and may include provisions establishing the criteria to be considered when an exemption is made. Restrictions. So paragraph 3. Refugee protections may not be referred to on application who A. is determined to be inadmissible on grounds of security, violating human or international rights, or organized criminality. B. is determined to be inadmissible on grounds of serious criminality with respects to a convention in Canada of other offense under an Act of Parliament prescribed by a maximum term of imprisonment of at least 10 years, or with respects to a convention outside Canada of an offense that, if committed in Canada, would constitute an offense under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years. C. Made a claim of refugee protection that was respected on the basis of Section F of Article 1 of the Refugee Convention, or D. is named in a certificate referred to in subsection 77.1. Considerations of application. 113. Considerations of application for protection shall be as follows. A. An application whose claim to refugee protection has been rejected may present only new evidence that arose after the rejection or was not reasonably available, or that the application could not reasonably have been expected in the circumstance to have presented at the time of the regulations. B, a hearing may be held if the minister on basis of prescribed factors is of the opinion that a hearing is required. C, in the case of an application not described in sections 112.3, consideration shall be on the basis of sections 69 and 290. I said 69, didn't I? But it's 96 to 98. D, in the case of an application described in subsection 112.3, other than one described in subparagraph E1 or 2, consideration shall be on the basis of the factors set out in section 97, and 1, in the case of an application for the protection who is inadmissible on grounds of serious criminality, whether they are a danger to the public in Canada, or in the case of any other applicant, whether the application should be referred because of the nature of the security, nature and severity of this act committed by the applicant, or because of the danger that the applicant constitutes to the security of Canada, and E, in the case of the following application, constitution shall be on the basis of sections 96 to 98 and subparagraphs D1 to D2, as the case may be. 2, an applicant who is determined to be inadmissible on grounds of serious criminality with respects to a convention in Canada punishable by a maximum term of imprisonment of at least 10 years, of which a term of imprisonment or less than 2 years, no term of imprisonment was imposed. And 2, an applicant who is determined to be inadmissible on grounds of serious criminality with respects to a conviction of an offence outside Canada that, if committed in Canada, would constitute an offence under an Act of Parliament punishable by a maximum term of imprisonment of at least 10 years, unless they are found to be a person referred to in sections F of Article 1 of the Refugee Convention. Effects of decision. Paragraph 114, subsection 1. A decision to allow an applicant to protection has, A, in the case of an application not described in subsection 112.3, the effect of conferring refugee protection, and B, in the case of the place of the application described in subsection 12.3, the effects of stay the removal order with respects to the country or place in respects of which the applicant was determined to be in need of protection. Cancellation of stay. 2. If the minister is of the opinion that the circumstance surrounding a stay of enforcement of a removal order has changed, the minister may re-examine in accordance with paragraph 113D and the regulations the grounds on which the application was allowed and may cancel the stay. Vacation of determination. So paragraph 3, if the minister is of the opinion that a decision to allow an application for protection was determined as a result of directly or indirectly misrepresenting or withholding material fact on a relevant matter, the minister may vacate the decision. Effects of vacation. Subparagraph 4. If a decision is vacated under subsection 3, it is nullified and the application for protection is deemed to have been rejected. All right, my friends, I will leave everything off here for this part of today, and I will be posting a second part shortly. Thanks for watching, and stay frosty.